A portfolio of intellectual property rights is simply one or more intellectual property rights. So that might include patents, trademarks, registered designs, unregistered designs, sometimes called design right, plant breeder rights, and copyright. Common aspects of portfolio management is first of all just getting them in the database so you can see what you've got, getting all the rights in one place. Another aspect would be, particularly if you've got a company where there are several subsidiaries or there is a foreign parent, you would need to decide which company is going to own which right, and of course that might feed through, have tax implications. Some countries give tax incentives for ownership of intellectual property rights, patents in particular in the UK, whereas others don't, so you might need to allocate different rights to different countries. Then there's the maintenance of the portfolio, so this involves paying renewal fees. There's a portfolio review. With some of the portfolios we manage every year, we have a review, which is basically just getting a big list of the patents or trademarks, meeting the client, going through them and seeing if there's any dead wood, anything which is not currently covering a product. For example, in the 2007 downturn, we had one client who came in. Obviously the 2007 downturn took people by surprise. Just got all the patents on the table, individual files, one by one. We went through them. Some of them were abandoned, the rest were maintained, and hopefully the client has now come out of that with a stronger patent portfolio and of course more cost effective because some of the patents have been abandoned. Trademark portfolios are slightly different to patents because what you tend to find with trademarks is, first of all, they're a perpetual right. With a patent or a registered design, there's a fixed duration, then it expires. But with a trademark, there's nothing to stop the trademark being renewed indefinitely. The things that could kill off an individual trademark right is failure to use the mark. But what we find with trademark portfolios is if you have a mature business with an existing trademark portfolio, there is often quite a lot of duplication where we have historical rights going back sometimes up to 80 or 90 years in individual national countries. But since then, we've had regional trademark systems come into force, such as the European Union trademark system, which includes all 28 EU member states, soon to be 27. So for example, if you have a French, German, UK and Spanish trademark, often these can be all replaced by a single unitary European trademark without any loss of rights. So there's this clean-up process which goes on. With trademarks, you also have this maintenance fee to pay most countries every 10 years. Additionally, with trademarks, if the mark has not been used for a continuous period of 5 years, it is open for somebody else to attack that mark and strike it off the register. So you can have a rolling program of refiling any marks every 5 years which you've not used. If you have been using them, of course, you don't need to do that. But if you haven't used it, but you've still got an interest in the mark, then a regular refiling program for unused marks is possible. We do have portfolios which include registered designs, and a registered design often accompanies a patent. So when I go into a company and they've got a new product, well, it depends on what the product is. If you're doing sort of consumer type products, they tend to generate more designs than patents because you've got the same innards for the machine. If it's a shower or something, the basic mechanics are the same, but every couple of months they redesign the shower to keep things fresh. So you generate more registered designs than patents. With a registered design, again we have individual national rights. We have a European right, which is called a community design, covering all 28 member states of the European Union. And then we also have an international design registration system under the Hague system. Historically, for UK customers or clients, the Hague system hasn't been well used. And the reason for that is that the territories were not particularly attractive. It's only recently that the European Union has joined the system, and it's only recently that the United States has joined the system, and China still hasn't joined the system. So it's only become really commercially attractive since the European Union and the United States have joined.